Welcome everybody to Spin Legal. And hey, you have a mug to show us.
Yeah.
All right. What does it read? What does it read?
This Mama Bear needs her coffee.
Okay. And
yeah,
Justin
even though it's backwards on here for some reason. Maybe when it shows on the internet, it doesn't. I don't know.
It doesn't show on the internet backwards. It was fine.
Yeah.
Okay. So it was your birthday last week, wasn't it?
Yes, it was.
Yeah, there you go. So
and
happy
this
birthday,
week,
Angela.
Our associate Justin's birthday.
Yeah, and happy
and
birthday.
We gotta take him out, do something with him.
Yeah. Okay,
because
so
I want him to do that, and then I'm going to take him out, but then we'll celebrate his birthday again.
Yeah, I seem to think there were some other people's birthday out around now, but I can't remember who. So hey, we'll get on with the show.
Yeah, that was Emmanuel. His birthday was there, but he's not.
Yeah. Yeah, that's true. Okay, so we are on episode 52 of Spin Legal, Wednesday, February 5th of 2025, and you're with myself, Peter Giblett, and Angela Browne, and we're partners at Invictus Legal LLP, and tonight I'm going to be talking about bail conditions in Ontario. Okay.
And it's based on federal legislation, but it's practiced in our courts.
Ontario. Yeah. And just to let you know that if you need to contact Invictus Legal LLP, you can do so at 905-688-5598, or you can email Angela at weareinvictus.legal, or myself at peter@weareinvictus.legal. Or you can go to our website, which is weareinvictus.legal. Okay?
Okay.
So let's start at the very beginning. What is bail and why do we have it?
Bail is when you have a criminal offense. You get charged with a criminal offense and you get arrested. And then you go in, and there's always a presumption that you're innocent, that you're not guilty when you get arrested. Okay? The whole theory behind that is only a court can prove that, and the whole burden of that is on the Crown to prove that beyond a reasonable doubt to declare you guilty of an offense. So when you go into a system when you're charged, there is a mandatory bail hearing, or sometimes you're just released, depending on the situation.
So you can be released. What's called police recognizance, right?
Yeah, it's called an ROR, basically, released on own recognizance, which basically is a type of bail where an individual is released, and it's based on their pledge to appear in court, and there may be some conditions where a person would have to sign to say stay away from the person they offended against, whatever, not carry any weapons, and keep their nose clean, that sort of thing.
But again here, hey, you've just committed a horrific 15 murders. You've even killed Carla Homolka, right?
Wow, I think we do the world a favor.
You're both a hero and a real sadistic bad guy.
You're a villain.
Am I going to get bail? Hey, I went for the baddest of baddest. No.
See, bail is determined. Bail is, you do have to go to court to have it determined. And it is a constitutional right to have, you do not have, like, you may not be denied reasonable bail without a just cause. And a just cause is based on one of the three grounds as follows: flight risk. That the judge is not confident that you're going to show up in court. For example, you got a passport, you are known to travel, you take a lot of trips out of province, that sort of thing, and you have the means to do so.
But hey, I've got not only the Canadian passport, but 15 other different nations' passports, right?
Yeah, exactly. Yeah. Right. And then there's also public safety. If they believe that you may pose a threat to public safety. If you came in and you were accused of killing 15 people, I don't think they're going to they're going to let you out,
No.
for bail, because they don't want another 16th person killed. And confidence in the justice system. Bail may be denied if the court determines that it may undermine the public's trust in the system. For example, if they just feel that this person has committed offense again and again, are we going to set this person out? Questions like that.
Yeah. Okay. All right. So I think we've gone through in some part who gets bail.
Yeah.
Typically,
and I think we have to be very, very careful, because sometimes we listen to politicians who will go out and say, we get too many people out on bail here and so forth. Yes, occasionally we'll get the wrong person on bail, or
right.
somebody on bail will commit another offense.
And the politician's probably going to say, bang them all up in prison from the day they're captured till the day they've served the last day of their sentence, and they shall serve every day of their sentence. But again, that's
making everything a lot more stringent and throwing everybody into the jail service that gets charged is not going to work. First of all, we don't have the prison space for it, and secondly, that may violate charter rights.
Yeah.
Okay? And we have to consider the person's charter rights. Yes, a lot of people are not getting bail, and no, I will not let your 15 people serial killer get out.
Okay.
Or people who give you weapons or who are charged with weapons offenses. There's a lot of controversy in that one.
Okay, so just to go for another thing, the bail basically covers there are conditions about what you may or may not do while you're on bail, and we'll cover through some of those in a minute.
What we want to talk about is the different types of bail that are out there.
Yeah.
In Canada or in Ontario. And some of them, one of them is called surety bail, which means that somebody is making a legal arrangement between the courts, and that's like when you're talking that you're going to bail somebody out, that you're it's usually a person's parents or a friend or maybe a relative, somebody who has
it's your cousin or something like that. Yeah.
Ensure that person is going to follow the bail conditions, and ensures that person gets in court when they need to make an appearance.
And the judge may ask questions like, so Angela, when you're going to be looking after your cousin, you realize that cousin Joey's going to be living in your home, and you're okay with that? Yep. Right? So that he might go into a lot of detail about that.
They do ask you a lot of questions. If you're going to be agreement to be a surety, even though I was very close relative to one of the persons I was surety for, they did ask a lot of questions about the person and how I knew about the person, and they're quite satisfied. And also, it looks better if you could pay, if you do have the means to pay, just in case there is a breach. Like sometimes what happens is you might have to pledge some money, like say if there's a certain amount of money, doesn't mean you have to go out to the bank and give them money. What happens is, okay, you own a house and there's some equity in the house, and okay, so you're going to pay $5,000, if there is an issue. But what happens is, as long as that person is following their bail conditions for the period of time that they have to do so until their trial or till things are concluded, that money is not going to be taken. But if that person leaves, like they just decide that they're going to skip their curfew, they're going to commit another offense, they're going to go out and leave the country, do something, that's pretty outrageous. Yes, that the surety can be made to pay that estrangement as well as the costs that it could.
And the judge at that surety hearing can ask questions like, and how will you make sure that Joey gets to his continuing hearings between now and his trial? And what are you going to do to ensure that he actually appears at his trial on day one and continues to appear until he's found guilty or not guilty.
Yeah. And this is one of the things that you do, like that's why they often live with their surety.
Yeah.
Okay? And they would say their inner surety would also ensure that the curfew is met and so forth. And if these things are not met and there's a surety, as I said, there's something called an estriat hearing. Okay, where
a question for you, because obviously you've talked about the person might live with their surety, and that might be a condition of the surety bond. Now, okay, so and also then that may then mean that the criminal trial is not tomorrow. Let's be honest about it, right?
It's going to be about 6 months, a year from now.
But then 6 months into the terms and conditions, I'm sorry, Joey's just driven you nuts. Is there any way out? Can you basically say
go back to court and you can ask them to remove you as surety, and that person would have to find either another surety or seek other conditions for their bail if they don't have a surety.
Yeah.
Okay?
So if Joey drives you nuts, you've got a way out.
Yeah, you got a way out just in case there's an issue. And sometimes there's a backup surety. Sometimes I will be a surety and maybe somebody else that a friend of mine also could be a surety, just in case there's an issue with me. Like if I travel a lot or I'm going to be on vacation, somebody has to be there.
Well, some of the bail conditions might well mean that the person is home between, let's say, between the hours of 7 p.m. and 8 a.m.
Yep.
Right. But if, for example, you have a job which means that you are you work on night shift, so you work 6 p.m. till midnight, you can't ensure that person is going to be at home while you're on night shift, can you?
Well, what happens is we learn about the person's work, what their job conditions are imposing, if they're a night shift worker or if they're a shift worker. We get the surety gets their shifts, their schedule. So, and they can only be outside of the bail times when they are at work. Or if they're studying.
No, sorry. I was meaning that the person, Joey, who is staying with you, is supposed to be in the house, and you're supposed to ensure that he's in the house between 8 p.m. and 8 a.m., right? But you work shift work, and now you're doing shift work between 6 a.m. and 6 p.m. and 6 a.m.
Yeah, and this is one of the things that you often negotiate when you're dealing with the surety agreement, because it varies between the surety. Sometimes they may not accept that if you're not if you have to travel a lot or if you're not home a lot. You may not necessarily be the best option. Oh, look who's here.
Yeah, you may not be the best option for that particular individual.
But they do ask a lot of questions. It's very in-depth. Like usually you speak with defense counsel and they interview you first, and then if defense counsel feels they want to propose you, then the court asks you questions.
And those questions can be quite tough, can't they?
Yeah, exactly. And there's lots of variants to the questions, and it also often varies to the offense as well.
Okay, so let's start to look at some of the and that's an important aspect about how it varies on the offense, because if you've committed a crime, let's say that the difference between, let's say, a theft under 5,000 versus a theft over 50,000, let's say, I don't know whether there's a point, but there's going to be more seriousness if you committed a theft over 50,000 than would be if you committed a theft over 5,000.
Under 5,000, if it was the first time, it's not likely that that you would be requiring surety. There might be some issue where you would probably have to make.
Typically, you'd be on an ROR there, wouldn't you?
And if you've done this 50 times before, the punishment gets more severe as you go up.
Yeah.
I mean, these things, there's so much consideration based on the person and their character, their background, the type of offense that's being committed. The whole element of the offense that's being committed, they cannot be it like there's a lot of things. What happens is all the court concentrates on is the risk to the public and also the risk of skipping bail, as well as the person, like in terms of their history. If somebody skipped bail before and it was 3 years ago they had something, and then they skip bail before, this is not going to be a likelihood. There's going to have to be some tougher guidelines around this, or maybe we won't give you bail. So they have to be they have to consider things on the balance of that to be able to tell a person not to have bail, and there has to be a just cause, a good reason not to give them bail.
Yeah. And obviously there are conditions which are imposed by a judge or justice of the peace. And some of these conditions we can just quickly run through. No contact orders. Right? For example, it's like, every time you come near Angela, Peter, you're a nuisance to society, and therefore I, as a judge, order you never to come near within 500 feet of Angela.
Yep, like their residence, their workplace, or if you just happen to be shopping, and just to avoid that person, right? Yeah. Like these are very, very strict guidelines, and you're not to communicate with them either. You can't just pick up your phone and text them. Like this is a lot of talking about a no contact order. A no contact order means exactly that.
Yeah. Okay, next one is curfews. So you may be given specific times when you've got to be at home, right? For typically something like 8 p.m. till 8 a.m. you have to be at home. If, for example, a person on bail actually has a job that means they will be leaving for work at 6 a.m., that's probably an acceptable variance.
Yep, they talk about the job schedules, and what they might have is that the curfew is, say, 10 p.m., with the exception if that person is at work. Yeah. And the person who is a surety would be given copies of their work schedule as a condition of their bail.
Yeah. And the point being is, yes, they finish their shift at 10 p.m. And again, there would be an order that they have to drive directly from their work site to the home. And they should be at home by such and such a time. And there's obviously sometimes there are even conditions, I believe, whereby a person can be given such a variance, but they give a number if they break down or something like that.
Yeah, and could be ways if there's a reason for it. And then also bail conditions can change. Like, say, for instance, if the person was charged with something like a computer crime, and they're not allowed to have even a cell phone, like a smartphone. And this is creating some problems for them because they need a smartphone for work and they travel for their work. So what happens is that has to be applied to the Superior Court of Justice to make a change. But quite often what happens is defense counsel gets together with the Crown attorney and says, look, this is a reality here. Can we be a little easier on this and try to exclude the cell phone ban?
Yeah. Okay. The other one that you kind of touched on there was travel restrictions.
Yeah.
The types of travel restrictions we're talking about is, for example, if you have a job that means that every other week you go to British Columbia, the rules might well be that, hey, that person cannot travel to British Columbia. They're no longer permitted out of the province.
Yep. And this was something that they would work out with their employer every year often, or if there's something that they can do in British Columbia. Sometimes there's a program where you can have somebody in British Columbia to ensure that they are indeed at work.
And the other way about travel restrictions, for example, might well be that your issue is with your ex-husband who lives in Peterborough, and therefore you might be banned. You live in St. Catharines, but you might be banned from Peterborough.
Yep, they do that. I don't know how they enforce it, but you are banned from Peterborough. You cannot go into Peterborough even for coffee and a sandwich.
Yeah.
So
Yeah.
that's what they do. It's these things could be strictly enforced. So if you happen to go to Peterborough, police could have you on the radar and they can see
Yeah.
you. Okay, so they have to watch. Okay?
Oh yeah. The other thing is might be location banned. Here we're talking about things like maybe you have a propensity to be violent when you've been drinking. So maybe a bar, you might be, banned from going to bars, or
And
the
also
other,
prohibited from drinking alcohol.
yeah. I
Yeah.
was also going to say that the other type of ban that you could be is that you could be banned from going to a particular, somewhat like a location travel ban. You're not permitted to go to, John Street in St. Catharines because that's where your ex-wife lives.
Mm-hmm. Yep.
That,
So
that
there's a
type.
lot of that that they could be put, and sometimes they would tell you to maintain your employment or maintain your
Yeah.
education, okay? Because if you're employed, they don't want you to quit your job and then suddenly take off somewhere. They want you to continue working, especially if you're local and you're working, okay?
Yeah.
They want to keep you around, okay? And the other thing is they may require you to go to counseling, okay?
Oh
Which
yeah.
is a very common bail condition, especially if there's a propensity around addiction issues or mental health issues that might have led you to commit the crime. So they might want to do that.
Okay.
Yeah.
There's another kind of one which we kind of touched on before with the sureties, is residence requirements. For example, a person on bail may be required on every night to reside at a particular address.
Yeah.
That might be the address of the surety. That could also be their own personal address.
Mm-hmm. Yeah.
Right?
Be the personal address. And also, it's also important to do that. There's a demand for what they call bail programs, where there's a bail program where people stay in, say, a halfway house type of thing.
Yeah.
And they have staff, who act as sureties, and they're making sure you don't go out drinking, you don't stay out after 10, whatever, and that you keep your job, that sort of thing. There are programs like that, and I think that's a good idea because not everybody who gets charged with offense has a reliable surety.
Yeah.
And
Well,
if they get a surety, they remain locked up, and that's a concern that is often facing many defense counsel.
Yeah, and actually, a residence requirement is not surprising, really. Although that said, okay, I'm going to ask a kind of rather awkward question here. So, okay, you got a residence requirement. You're required to continue to live at 124 Western Avenue, right?
Mm-hmm.
But you lose your job.
Mm-hmm.
Right. And now, of course, that means that because you've lost your job, even though you've applied for EI, now you've actually, now you stop paying your rent.
Oh boy.
It's not going to stop you just because there's a residence requirement that you stay in that address in Western Avenue. Is not going to stop you from being evicted from your rental accommodation.
What generally happens is this is raised with defense counsel, and then you might have to change where the residence requirement is. Like, say, if you're going to be spending a little while in your parents' basement, that's probably what you're going to be doing. Is your new residence requirement is in your parents' basement.
Yeah, because you're not going to stop the eviction, right?
Exactly.
You're going to be evicted by the LTB if you didn't pay your rent, and that's just pure and simple what it is. And while the judge might well ask about questions like, is it rented? He may well also make statements like, you must continue to pay your rent during the period. But of course, what he's not going to be able to do, no justice who can be able to deal with that. They're not going to be able to determine that one must keep one's job, right? Yes, as far as you're concerned, you can't leave your job, but That's not going to stop
But they
your
say maintain
employer
your
from firing
employment.
you.
They're saying you don't leave your job voluntarily.
Yeah,
Okay? Like they don't know whether 3,000 people are going to be laid off at your workplace the
yeah,
following month.
yeah,
Right?
exactly.
Like,
They don't
judge
know.
that.
Yeah, they don't know that the Ford plant is going to close, for example. Do
Yeah,
they?
exactly. So these things like that
Yeah,
are not predictable. But
yeah,
what they're trying to prevent is somebody, well, I'm going to quit my job and I'm going to go
yeah,
thumb my way to Vancouver, that sort of thing.
yeah. Vancouver, I'm going to Florida, mate.
Yeah.
Yeah,
Well, we'll stay out
yeah.
of Florida, at least for a little 4 years or so.
I'm joking, of course, but yeah, you know where we're coming from. But the
Yeah,
point
exactly.
being is that you're not permitted as you can't do nothing about what other people do, but as a person on bail, there can be restrictions like you're not permitted to leave your job unless you've got another job lined up, right?
And there
So
are people who are not allowed to use a computer,
yeah,
right?
exactly.
Except when it's on their employer's computer, where they
Well,
can.
actually, that could be kind of hard if your job is a computer programmer, couldn't it?
Yeah, yeah. If you work from home, God.
Yeah, if you work from home and you're a computer programmer, but yeah, that could be rather hard. Yeah, so
exactly. I don't
those
know how
kind of
they
things.
do that personally.
Yeah,
Okay?
that probably
Things
terminates your
they try to
employment.
work in the best way possible because again, there has to be the confidence in the by the public, okay,
Yeah.
so that they are seeing that you are doing something that's working.
Yeah. And so there's a lot of kind of delicacies that the justice has to actually go through in terms of deciding what these bail conditions are.
Yep. Yeah, they go back and forth with it, and they're trying to do this with the person, so it's not, and that's why when the defense counsel they interview the surety and the possible surety, and the surety really needs to know the person well and what their circumstances are with work, with where they live, with different things like that, and they can kind of understand what is possible for that person. Okay. And if the person is, say, a sole parent, and they have to make arrangements for the children if there are issues with the children. Okay. So there's things like that they have to do. So that these things can be complicated. What they call it is a bail preparation plan. And that's the first step they do. And they make a proposal until the courts are satisfied that things are going to do. Some people are never let out for bail, for the obvious reasons.
Oh, obviously, if you're
be let out.
Yeah, if you're a murderer, rapist, you're probably not going to get let out.
Yeah, exactly, because this is they shouldn't be let out, and they need to be.
And if you're a 15-time offender, again, you're probably not going to get let out.
Yeah, exactly, because most get sick of people doing that.
Yeah, even if the charge is stealing a $200 cell phone, you're still probably not going to get let out. 15.
You have to be very, very careful with these things because this is where the responsibilities,
Yeah.
And the responsibilities, as I said, when you're a surety, you have to make sure that these conditions are met. And and then, of course, if you do grant money surety, there could be an estriat hearing. An estriat hearing is a separate hearing that's heard by an estriat judge or master, where they actually hear the case to determine whether whether the breach of the bail was within the surety's control or not.
Yeah, okay.
Sometimes it wasn't within their control, right?
Yeah,
but if it was within your control, then you could end up paying at least some of it back into the
we'll
courts.
We'll get to that later on. Okay, some other bail conditions before we get to sureties. Surrender of passport, that's an obvious one.
Yes.
Now, okay, so one...
You're known to travel, grab your passport and it's got to be surrendered.
Yep. The other question here is like, hey, you've got 15 passports. I know you have, Angela. You're a native of America and the Guadeloupe Islands as well, aren't you?
It looks a little suspicious here.
Give us all 15 passports.
Mm-hmm. Looks a little suspicious here that you got so many passports.
Yeah, but
Yeah.
so they can do foreign passports as well, can't they?
Yep, they can. It's any
Yeah.
passport that would keep you from being part of the thing.
Yeah. Okay. Another question here is regular check-ins.
Yeah, regular check-ins. There is certain there's certain types of things where you go to court. Sometimes they will have you go to court on a regular basis just to do your set date and so forth. And if you're involved with something like a counseling program or a drug rehab program, they want to make sure that you're actually doing it. They
Well,
want in the
obviously,
drug program or the alcohol recovery program that you actually are attending and
yeah.
staying
And
with the program.
obviously, those are quite important aspects of it, aren't they? Because from the viewpoint of the alleged offender, if they are going to be going to a court and they going to trial, and at the end of the day they're found guilty based upon what has happened within the case, the fact that they may have gone through some form of drug rehabilitation or alcohol abstinence program may in fact actually help them in their sentencing.
Yeah, exactly. And very much sometimes at the beginning of it, if it turns out the person has not really had a lot of history with committing offenses, but may, for example, have drug addiction issues or mental health issues, there are diversion programs that are available for
Yeah.
people. And even the diversion programs require regular check-ins where they go into the court and then they talk about their treatment and they send it into the court for proof that they've attended and how they're progressing and things like that. So there's a lot of stuff there. Like it's not good enough to walk in and say, yeah, I attend AA meetings every night.
Wait,
They actually have to have a signature from somebody there.
I was going to say you need the paperwork
Yeah,
associated with it, right?
exactly. Yeah, so somebody has this meeting at the West St. Catharines, they sign, that you were in attendance. And then another one you go, they signed it, you're in attendance. Then you
Yeah.
have all of these AA meetings that you've signed. It says, okay, I've attended these AA meetings.
And unlike probably when you get regular attendee at an AA meeting where you come, you say hi to people, you say your bit within the AA, and I'm not demeaning anything to do with AA, but typically what'll happen there is in a regular AA meeting, you'll come, you'll go, and maybe somebody might notice if you don't come on a regular Tuesday night,
Yep.
right? And your sponsor may call you up and ask you what happened last Tuesday, what went wrong, because they're concerned that you're falling off the wagon. In this particular case, when you're going there, somebody has to sign you up, so it's a level degree more serious.
Yeah, definitely.
You signed in, you signed out.
Yeah, exactly. And it's strict, because they want to make sure you're doing this. And if you haven't been able to attend the AA meetings, there has to be a good reason. Right?
Okay, here's a good question from one of our listeners. Can you ask for a reduction in bail or not?
Oh, yes, you can. You could. Hey, if you have a certain term for bail or conditions of bail could be changed by making a request or a motion through the Superior Court to amend your bail conditions. And sometimes these things could be sorted out between the defense counsel and the Crown, who then goes to court to have it amended. So these are things that have often happened. But generally, they don't take you off bail when you're still waiting for a trial. They have you in bail. Sometimes you can end up with some.
Well, that's what we were talking about earlier on, about you lose your job or something like that.
Yeah. I've had some people who came up. They had some pretty liberal conditions on their bail.
Yeah.
They can come and go as they need to, and as long as they keep working, and get counseling, that's all they cared about. And they checked in periodically, and as long as they did that, they didn't have to have a curfew or anything. There was no surety, so some of these things are people could be It depends on the person, because some people are very responsible and will take responsibility, and other people won't. Okay, so
Mhm.
it's like sometimes it's a gamble, if person's new, that sort of thing. But as people get known through the court system, hey, sometimes it's a little bit of definite no.
Okay, the next one's an obvious one. The next one here is an obvious one. This condition, prohibition of firearms.
Absolutely, they don't want
Anybody-
people to. What that does, it goes on your license, on the bail condition, and in the court system. So, say for instance, 5 years from then, you want to go out and buy firearms. That could still be on your record. Okay. That can also be fought and then saying, I
Okay,
want to have that prohibition removed.
okay. So let me put another one up there in relation to this. You do a stupid thing, but you're an Olympic shooter.
Mm-hmm.
Right? So therefore, you do have firearms. You've got 25 of them in the shooting club.
Mm-hmm.
You've got licenses for all of them.
Mm-hmm.
Now, what has to happen in that sort of scenario?
I'm not sure how they would do that, but I'm sure that they would not be permitted to operate using the firearms. They may have to have the firearms into someone else's possession. So that
If they're at the club, the likelihood is that they could be barred from going to the club. So that could be a
yeah,
location ban.
that could be a location ban, that sort of
Yeah,
thing. And you know, a lot of these things, like a lot of them, they throw this prohibition of weapons in just about a lot of cases,
yeah.
and some of them have nothing to do with use of a firearm.
And
Right?
in fact, in Canada, here in Canada, of course, we're talking about, it's not the same as the USA. A lot of prohibition of firearms. I'm sure if you and I were had firearms prohibition, it wouldn't change our lifestyle one
Yep,
bit.
exactly.
Right?
I don't own them, but we used to work.
Yeah,
I used to have them when I was up north, and we used to operate guns and
yeah,
so forth. But the thing is, they're fully licensed, fully trained, and
yeah,
that sort of thing. So
yeah.
these things are, and for some people, that's very important to them.
Okay. Anything else in the bail process that we should consider?
Okay. Jumping bail, you could be put back in jail.
Yep.
And if it's something that your surety didn't supervise you properly, or the estriat hearing, they might actually have to pay the money that they said that they would keep you for.
Okay. So I'm going to be asking a daft question here because it occurs to me. So, hey, I leave my home in Niagara Falls. I'm driving to Hamilton to attend my trial, but I break down on the QEW and my car just boom, right, catches fire, and I'm standing on the side of the QEW.
Call the courthouse, and then
Literally.
somebody can call the police or CAA or something.
But I
So,
don't have my phone. It just burnt. It just burnt in the car.
oh God, oh God, I don't want to be you.
Yeah, yeah. But again, if you explain that situation to probably a police officer that will pull over in that
Yeah, and
situation,
they will check it, and they'll
they
check
will
it,
check it and they will probably assist
and
you
then
in
they
that
will
scenario.
contact the court. Which court do you
Yeah.
have to go to? And they will
Yeah.
contact if they know who to contact.
Oh yeah, absolutely. Yeah.
Yeah,
Yeah.
because these things. I mean, it's happened. It's happened. There was a guy who was accused of kidnapping his own kid, and he got stuck right in the
Well,
middle of nowhere.
there was an Amber Alert in exactly that
Mhm.
situation whereby this person from one, I think it was from Niagara. He was coming from Niagara. He's supposed to return his kid to Berry, and he broke down in like rural Niagara.
Yeah,
Car
not
didn't catch fire, but he broke down, and he didn't have a phone on him. Right.
yeah,
That's the point. He realized I left home without a phone, and there's nobody coming down that rural road ever.
and
Right.
it's very, very hard. So probably
Yeah.
somebody had to get the police or something, and then he would have
Yeah.
to report it. So I mean that happens, and the police will help you, in those
Yeah.
situations.
Yeah. All right. Okay, so one important thing to note about bail is that the accused must agree to all of the conditions of their release order before they leave the court.
Yeah, or the police station or wherever they're getting their bail conditions from. Okay, so they have to agree, they have to sign paperwork, and if you have a surety, the surety has to sign the paperwork.
Yeah, I was going to say that I was actually at a bail hearing whereby obviously one particular individual came into the dock and he's going yes to everything, even those things he should have said no to. And he looked almost as if his eyes were glazed over, and he said, "Yes, I agree to the bail conditions."
Yeah, yeah. And
I'm
don't
thinking
use
to
drugs.
myself,
I'm not going to use drugs.
well, I'm just thinking to myself, there's no way they're going to release this guy on bail, and like
Oh,
he's
yes.
walking out of there in 10 seconds.
Yep. And these are things that, like, the courts are used to people like that. And sometimes you get some judges who are pretty good at reading people.
Yeah. Okay, so moving on, surety bonds. So we just talked about how the bail process works.
About how it works because
Yeah.
it's not an actual cost you have to pay in, but they often assess a monetary value. The worse the offense is, the higher the value of the surety is. And quite often, if it's a very serious offense, they would put that like if you own a home, hey, and you have equity in the home or some other kind of security, like if you own stocks and bonds or something that you could use, they want to know that so that they have it just in case somebody jumps.
Okay. But if they jump, surely we're going to be calling Dog the Bounty Hunter or Canadian Dog the Bounty Hunter, aren't we?
Yeah, I'm sure we got Dog the Bounty Hunter here, but we don't. We don't. What happens is the court will the police will go out, get the person, and they often have to be reincarcerated, and there may be additional costs to the surety if it can be shown that the surety did not properly supervise. Like, say for instance, if it can be shown that the surety said, yeah, go ahead, go out and have your party, right? Or if the surety just left their place, and the person just threw a big party while they were gone and took drugs when they're not supposed to.
Yeah. And we talked earlier on about, for example, you as a surety of somebody. Hey, Matthew's going to be staying with you for until the trial. Is that okay, Angela? And you say yes. And then 6 months in, you kind of go, well, I don't want Matthew here anymore, right?
And I can go back and I can request to the court that I would like to cease being a surety. Okay.
Yeah.
That's fine. The court will release you. Okay. And then somebody else can take over. Okay. And that person would have, if that person still needs a surety, that person would have to find another surety.
Yeah.
Or they're back
okay.
in the...
Okay. Okay. So contract surety bonds. We were talking about those whereby it's not a member of the family that raises surety, but somebody else.
Yeah, there are situations where there are people who do this. And it's like, as I said, one of them is where you have like a bail recovery program. Somebody's in that program and they have staff that you live with and that you go home to, and they work with you to make sure you're meeting your conditions. Okay?
Yeah.
And I think that's an ideal program to have. Okay? Because some people just don't have anybody that they can use as a surety.
Yeah. I was going to say, if you're like, for example, and if you're a new immigrant, you've come here to Canada on your own.
In Canada.
Yeah, you've got nobody else in Canada. You're in a really bad situation in this particular instance. And I know, we're not going to the extent of, hey, they're a criminal, that we should deport them. We're not. It may
not be a deportable issue. Who knows?
Yeah.
Okay, but they would have to have somebody who would look after it, because again, you're presumed innocent until you're proven guilty.
Yeah. And you can only be deported once once you've served your sentence anyway, right?
Let the court determine whether this is a deportable issue.
Yeah,
Right?
exactly.
So I mean, this
But
is
I'm
why,
just saying,
yeah,
that as a newbie to Canada, you'd need somebody who can actually
yeah.
raise your surety for them,
Mhm.
and so there's, so it's good to have these kind of programs.
Yeah, so
Right?
it's really helps people with that. Yeah.
And okay, estate administrator bonds is required for an estate executor. I'm presuming here is this where the surety dies or something?
Possible, right? Because sometimes that happens, and their executor would, but then that has to go through the courts,
Yeah,
right?
and
Because again, you're looking at another person
yeah,
to be
I
taken
was
to
going to say that
the amount.
almost any change.
And part of that money that goes out could be held in kind of escrow until the bail is over with.
And sure, and you were talking about changes to conditions for bail conditions. The same applies here to when you got surety involved in it, because if, for example, the person whose surety does die, it does, bound to happen sometime, there has to be somebody who can, either maybe their wife continues on, or husband or wife continues on, or then maybe they're prepared to continue that on, and now you've got to go to cousin Joey instead.
Yeah, and the thing is, there could be an estate, an administrator of an estate, and part of that money of the estate could be held back and held aside as potential surety bond for respect to, like, say, if they pledged $100,000, for example, for a pretty serious offense, on that, that money can't go anywhere until after the whole situation is over with. And if they don't need to pay it, everything turned out okay, and then they're back out of the justice system or they're in jail, whatever, then the rest of the money could be released as accordance to the will.
Which possibly mean that, for example, estate property can't be sold for a particular period of time.
Yeah, there's a lot of that tied up too. Yeah,
Yeah.
so these things are very important. It gets into civil law, which is always interesting when you get different types of things mixed up in civil law, criminal law.
Okay. One of the things we need to talk about is rules for violation. So what happens when you break the bail conditions, or when you break your surety conditions?
You could be sent back to the clink.
So handcuffs on, sirens are blazing, and you're going back to jail.
Yeah, and this is one of the things that they ask you when you're agreeing to be a surety. Are you willing to call the police to have them put into jail if necessary, if there is a breach? They do talk to you about it. Some people are not willing. Some people will protect their kids.
Does that basically mean, okay, so Angela, you're not willing to call the police if your son reoffends? What if I were to say that wouldn't be acceptable? You must be able to do that if you're going to stand surety for your son. That might be the kind of question that the judge may ask.
They do. They will ask you that kinds of questions, and they do. And the Crown attorney will ask you that too, because they want to make sure that they have somebody that's good and that's going to work for them, right? Because they don't want to have somebody out there who's going to be reoffending. Because again, it's confidence to the justice system.
Okay, so you just talked about the Crown attorney there. There's got to be some occasions when the defense and
the Crown participate in the bail hearings.
Yeah, I was going to say there's got to be some occasions when a defense attorney is saying we should let him out on bail or for surety, and the Crown says no way, no how.
No way, no how. I know this person. He's been in here 15 times before, and I'm I know this guy, they can do that. And the defense says, no, but he's changed. He found Jesus.
Yeah. So what happened?
They have that debate, and these facts have to be put forward. And you can't just put forward something that, like, these things are submitted to the court. Any
Yeah.
kind of proof of things, persons recovered from, they're no longer addicted to alcohol like they were 5 years ago when they had the last offense. And alcohol was a major factor. So they can actually show that they are no longer addicted and that they've recovered. They're now working, that sort of thing. So that could look better on a bail hearing.
But the kind of more conservative way to say that is, hey, yeah, I don't believe it for a second. That guy, if he was 5 years ago and he's claiming reformed now, why is he offending again?
Yeah, that's also another question too that they do ask. And so generally what happens sometimes is that they may grant bail, but then the Crown may want to add some conditions.
Mm-hmm.
And the Crown will propose certain conditions for the bail. Both sides can propose conditions or object to conditions.
Yeah. And some of those,
the day, then the judge will go through it and it says, okay, this is the following conditions. And they talk to the person who's being let out on bail. And they said, and this is something that either to the person who's a surety or the person who's the bailee or both, right? To get them to understand what they can and cannot do. Right?
Yeah. And those conditions can be quite strict. They can be things like between the 500 and 600 block of Young Street, you will not be on the left-hand side of the road. You must always walk on the right-hand side of the road.
And this is where has a lot of importance in this type of stuff. And that's why a person would need to understand that. So, and they would have to agree to that and understand the consequences of failing to follow that. Right?
Yeah. And I picked a very pernickety type of condition there, but there may well be a valid reason, because in fact, in the 500 to 600 block on Young Street may only be 10 doors away from where the offense occurred, but there's a recognition that you need to be able to go up Young Street in order to go to work.
Yeah. Like there's all kinds of offenses they have to look at. Every offense is different, and sometimes every offender is different who might have done the same thing. So this is why these things are done, and that's why we have defense counsel and why we have Crown. And people who don't have lawyers immediately, they can use duty counsel. A duty counsel can assist them at a bail hearing.
Okay, there's another question here. So if, for example, a person gets is on a charge, the bail conditions are fairly loose, fairly relaxed. Every 2 weeks you've got to go and see report in, but apart from that, you've got no specific conditions.
Mm-hmm.
But if something occurs, for example, to that individual and they don't report, let's say they don't report next Thursday tomorrow on Thursday, they didn't report last Thursday, you found them today, but they're still on bail, you typically would be tightening up the conditions.
Yeah, like sometimes what happens is the police might make an inquiry, because often they have to report to the police station if they have to go somewhere or they can't come in, or they also talk to the police. I just moved. I had to move, and this is my new address.
Yeah.
Right? Because that's generally what it is. They don't tell you have to stay at 123 Young Street. Okay? But I can't stay at Young Street anymore, but I now moved to 567 Peterborough Street. Right? Yeah. So you go to the police station and show them the release that I've just moved. Right?
But again, if you moved from somewhere, let's say from, St. Catharines to Hamilton, for example, there's a possibility that could be a violation of your bail condition, couldn't it?
Yep, because they may tell you that if you move, don't leave town. Remember, you watch all these movies, they say, don't leave town.
Yeah. Yeah. Okay. So that's, some things to think about in terms of bail bond, surety bonds and other things. But as you said in the first instance, there's a large amount about, unless you do really committed the most horrendous of crimes, there's typically we don't want to fill our jails up with people who could be found not guilty.
And this is where people have to be considerate. Like, you have politicians out there, I will not name them, but we have politicians out there saying we shouldn't have so much bail for people.
Yeah, bang them up.
Like, everybody who gets let out on bail is out there reoffending, and they're all violent, and they're all dangerous. There are some
that reoffend.
Yeah, let's deal with those. Right?
Yeah.
And the system has in place what they have. And there is also people who are out there, and they will deal with it. So just talk to any police officer who deals with this stuff, and they will tell you what happens when somebody reoffends.
Okay. All right. And there's basically, it is treated very seriously by the courts. Unfortunately, we sometimes consider that it's not treated as serious. Some politicians consider that it's not treated as seriously as it should be.
Why? Because it's politically palatable.
Yeah.
To say, I'm a law and order politician. I want to keep the community safe.
Yeah.
Okay?
And again, it doesn't.
You understand why somebody would support that.
Yeah. And it doesn't matter the color of your political stripes, that typically you will be, a law and order, there will be law and order politicians.
But when you're looking at things academically and research-wise, the statistics are low. Okay? Given that they're there, let's deal with the ones that are there and make sure you have a good system to bring them back in.
Okay.
That's
so
what's I'm protecting those that have and who are following their conditions, to make sure that they have the rights.
Yeah. Okay. So that's been an interesting run through bail, and typically, as you say, bail is for the least for the people who committed minor crimes. The typically
serious crimes too. Okay? But they are people usually like who might have. There's circumstances when you commit a crime, like you're provoked, or there was an allegation that you raped somebody, but you date raped, right? Things like that. Okay? And they can make quite a thing, and sometimes a person would pledge quite a significant amount of money for that. So if they breach, remember that guy from from CBC, Jumanji or whatever? Hey, Jumanji. Yeah, he was. He supposedly had sexual assault against 3 women or something, and they went and accused him that. He was on the CBC, and then he got off, right, because they couldn't prove their burden. Like, it doesn't mean that he's innocent. It just means that the Crown has failed to prove their burden.
Yeah. Okay. Absolutely.
Yeah.
Okay. And so that's a whole, that whole thing about criminal burden, etc., is a whole different discussion entirely.
Yes, exactly.
Right? What we're talking about here is the run up to going on trial. What happens between being arrested or being picked up by the police, whether and going to face your trial.
Yeah, exactly.
Yeah. And okay, so in that regard, if you need to contact Invictus Legal, you can do so at 905-688-5598. You can email Angela at angela@weareinvictus or my .legal, or myself at peter@weareinvictus.legal. Go to our website at weareinvictus.legal. Got one comment here, Betty. Hello, Angela. What if you witness a policeman hurting the victim and it's seen by many? She did not try to resist. She was tied. Cop slams her face down on the ground. That's likely a criminal offence, and that's
committed by the police.
Yeah,
and
it's not.
You report the police, not only criminally but also to the police, and they have their own tribunals, and they can actually lose their job.
They can. That's for sure. That's a very serious matter there.
Yeah, exactly. And some police have done that.
Yeah.
Okay? And it's like where they do it, and they can possibly also be sued, okay, by the victim. Okay? The police department could get sued for, I guess, undue pressure or force on them.
But again, lawsuits and that are actually outside of this discussion. If you took a lawsuit against the police, that's there's a process for that.
Yeah, exactly. These things you have to go through another process, and we can talk sometime about police issues, about policing.
Yeah. Okay.
But right now, this discussion is just about bail. But I appreciate your questions, and I think that writing us and asking us to talk about certain things, we will do it.
We can talk about that another week. All right.
Yeah, maybe we can talk about that, about police and police brutality.
Yeah,
right? It happens.
Well, police and police brutality is a big issue, and there's a largely political issue. But yes, it's an important question.
And George Floyd.
Yeah, even though that's America, it's not unusual that things like that occur even in Canada. Yeah. Okay. And just as a quick thing, so you can contact us at 905-688-5598 or email us at our email address, or you can go to our website. And Angela, your favorite part of the day.
So what we heard today on Spin Legal, whether it's this show or any other shows that we did in this series, is not legal advice. It's just information and discussion and opinion, conjecture. But however, if you need legal advice at all, please contact a paralegal or a lawyer. Be nice to talk to us, and if we can do it and help you, that's great. But if you want to talk to another paralegal or another lawyer, go ahead. And it's very important to get proper legal advice before you act on anything when you feel you have a legal issue.
All right. And I want to thank you all for being here, and have a great week. Stay safe. And just because crimes do occur doesn't mean they're around every corner.
Yep, exactly.
And I think that's something we always say when we're talking about criminal law. All right. So thank you, everybody, and have a great